The next part of the government's argument is that 18 to 20-year-olds are not part of the people under the Second Amendment. The government next asserts that 18 to 20-year-olds are not part of the people whom the Second Amendment protects. This argument is based largely on common law's recognition of 21 years as the date of legal maturity at the time of the founding, and the fact that legislatures have long established minimum age requirements for various activities. Since when has personhood been age-dependent? While in ages past, yes, 21 may have been the age of legal maturity, what does that have to do with a natural right protected by the Constitution? The operative clause of the Second Amendment states that the right of the people to keep and bear arms shall not be infringed. There is no age or maturity restrictions in the plain text of the amendment, as there are in other constitutional provisions. This suggests the Second Amendment lacks a minimum age requirement. So the Second Amendment doesn't have a minimum age requirement. What about this not a person nonsense? Moreover, in the unamended Constitution and Bill of Rights, the phrase right of the people appears in the First Amendment's Assembly and Petition Clause, the Fourth Amendment Search and Seizure Clause, the Ninth Amendment. All of those references confer individual rights and undoubtedly protect 18 to 20-year-olds as much as 21-year-olds. As I've always said, any right of the people is an individual right, and unless restricted by the Constitution, age doesn't matter. Still, the government emphasizes that the right to vote from the founding up to the 26th Amendment was typically reserved for citizens over 21. Thus, because voting is a hallmark of membership in the polity, 18 to 20-year-olds were originally and now remain excluded from the political community described in Heller. Is it just me, or is the government simply ignoring the fact that it wasn't the Constitution or the federal government who put age restrictions on voting before the 26th Amendment? They also seem to have forgotten Section 2 of the 14th Amendment. The court noted the issues with this position. This argument is incompatible with Second Amendment precedent, nonsensical when considered against the backdrop of American suffrage, and contradicted by the history of firearms use at the founding. So far, I'm with the Fifth Circuit, but is that the only argument against the not part of the people nonsense? Thus, to say that the people covered by the Second Amendment is limited to those who are part of the political community at the founding would imply excluding law-abiding adult citizens based on property ownership, race, or gender, just as denying arms as only those arms in existence in the 18th century borders on the frivolous. Likewise, attempting to limit the people to individuals who are part of the political community at ratification is ludicrous. Sounding better at the Fifth Circuit. With these two strikes against the rules, can the courts find a third? Finally, the history of firearms use, particularly in connection with the militia service, contradicts the premise that 18 to 20-year-olds are not covered by the plain text of the Second Amendment. That seems to make sense, especially since our sixth president, John Quincy Adams, drilled with the Massachusetts militia, I believe, at the age of 8. The Second Amendment's prefatory clause states that a well-regulated militia being necessary to the security of a free state. While Heller recognized that the central concept of the right to keep and bear arms is self-defense, the prefatory clause announces the purpose for which the right was codified, to prevent elimination of the militia. The framers knew all too well the dangers a disarmed and defenseless public could face under monarchical control. Since the purpose of the Second Amendment is the question of self-defense, why would an 18-year-old be able to own a handgun but not purchase one? The Second Congress consequently enacted the Militia Act of 1792, which stated in part that each and every free, able-bodied white male citizen of the respective states resident within who is or shall be of the age of 18 and under the age of 45, except as herein accepted, shall severely and respectfully be enrolled in the militia. If an 18-year-old can be part of the militia, why not purchase the weapons that would be necessary to join? Finally, the government argues that mere participation in the militia was not enough to establish Second Amendment protections because, well, black men served in the militia but were otherwise barred from possessing arms, and 2, Virginia by law disarmed men who refused to take a loyalty oath while still requiring them to enroll in the militia, albeit without firearms. The treatment of blacks is hardly probative as an 18 to 20-year-old because race-based classifications would apply regardless of age. Are we supposed to enforce our laws based on the racist policies of the past? And how does a person's race equate with their age when it comes to purchasing a handgun?